So, a father is more than a breadwinner. A father is more than a disciplinarian. A father is a protector. And that's not just the standards that we set in society, although it is. It's also a legal duty imposed by the state of Texas, right? To all fathers and to all persons who take care, custody, or control of a child, right? So if the defendant had abided by that duty, we wouldn't be here today. But since we are, it's my job at this point in the proceedings to kind of recenter your focus on what it is that you, as the esteemed juror members who are deciding what the facts are in this case, what is really at issue that you have to decide. Because some of the things, of the entire universe of things that the state might have possibly had to prove before the case started, the universe of what we actually are in dispute about is very small, right? So I'm going to show you, this is paragraph A, right? These are all of the elements that the state has to prove. Most of these are not contested, right? August 17th of 2021, that's the date Benjamin died. We know that we're talking about that day and the year or 10 months preceding it, right? We're not unclear about what person we're talking about when we say the defendant, the father of the child, Brandon, right? Intentionally or knowingly is in dispute. I'll talk about that more, and Mr. Villarreal is going to talk about it more. I expect Ms. Sawyer will also. By omission. What we're saying by omission is we are establishing the distinction, right? When you have a duty to do something and you do nothing, that is an omission. So we are talking about not actions that were done, but failures to do actions, right? Caused serious bodily injury. Now, there is some dispute here. Obviously, Benjamin died. That would be included by serious bodily injury. But that is not the extent of what you are to consider. Because you are to consider all potential serious bodily injuries, including those suffered by Benjamin before his death, based on the failures to act by the defendant. So it's not just death, it's SBI, serious bodily injury, the impairment of any bodily organ. That could include things like failure to thrive, stunting. Who we're talking about is not an issue, right? Benjamin Cervera, very clear who that is. Assumed care, custody, control of Benjamin Cervera, and by failing to do something, the three things, right? Adequate nutrition, adequate hydration, proper medical care, right? It has to be the failure to do one of those three things that causes a serious bodily injury. Compare it to paragraph 2. Really the only difference here, if we look, going back from A to B, it's just that now we go from care, custody, control to statutory duty to act. That is empowered, that is required because he is the father. So the first is saying he, like anybody could, takes care, custody, control of the child. He is now responsible for its medical care, for the treatment, the food, the water, right? Compared to legal duty to act, when you are the father, you always have those duties, right? Okay. So, what I want to focus on is the intent. And what I think you can conclude from looking at the evidence in this case, very important. You don't have to agree as to if it's intentional or knowing. You all just have to agree that it was one of the two. You don't have to agree on the injury, just that there was serious bodily injury. And you don't have to agree on which of the manner and means, by failing to provide hydration, by failing to provide medical care, by failing to provide food, nutrition. It is only if all of you find one of them, right? So you could find that you believe he intentionally withheld food and that caused the death. That's a guilty verdict. You could find knowingly withheld medical care caused SBI, not death. Also still guilty. The fact that the two of them are different injuries, different instances, and different causes, all that matters is that he had a duty to act. His failure to act caused the serious bodily injury or death by one of those three means, right? So if we're talking about the intent, I believe that the evidence in this case proves that it is an intentional deprivation of food, medical care, and hydration. Why do we know that? Look at the apartment. Everything that we know about the apartment. The first thing that we know, right, is that cameras are installed to view the children and the kitchen. And these aren't security cameras we're talking about in the sense of there's not one outside watching the entryway to the home. There's not one pointing at the door, the only entry. There's none pointing at the windows to enter, right? Where are the cameras? The children's room, the kitchen. There's one in the living room. Where does it point? Down the hallway to the kids' room, right? Why are those cameras there? Why were they placed there? Is it not to monitor the children? Monitor the children because you think that there may be something wrong. Something that, for example, you might have wanted to consult a medical professional regarding. Well, these cameras are here at the beginning of June. It's not until CPS makes them take him to the hospital on the 21st of July that he's sent to the hospital after the cameras are installed. And what do we know about those cameras, about what is present in the home, right? Once the cameras are in place. Well, I don't know why the pictures aren't working. Here's what we know about it. The beginning period in June, right? The cameras are in place. What is on the locks? What locks are present? There's that little plastic internal lock that's in the cabinet, right? There's a similar lock that's on the refrigerator. That right there is proof of intent to deprive food. Like, I am intentionally restricting the amount of access that he has, right? And I'll remind you, those two controls, those aren't present on the medicine cabinet. They're not present on the cabinet under the sink. They're on the pantry and the refrigerator, right? And then the security footage captures him suspiciously in the middle of the night, getting up, eating watermelon, eating a fruit cup, drinking milk, all those things he ate that night, indicative of perhaps he's having food withheld from him. But those barriers that were placed in front of him, he was able to get around them, right? Uh-oh, the little plastic thing, he must have figured out, he must have seen someone do that and figure out how to do that. Well, that's unacceptable in the eyes of the defendant. So we're going to now install additional locks, like hard metal locking with a combination. Where are those? The same places. The places where the food is. What about the room itself? The gate is there pretty much early on. The whole time that the surveillance is there, there's the baby gate there. Then you see Benjamin trying to climb over the baby gate. And hey, he climbs over the baby gate. So what do? We put a lock on the door all the way at the top, right? And so then what happens? Well, Benjamin, he just doesn't like being locked in the room all night by himself without access to food, without access to water. So he's going to drag the desk over to the door to climb up on it to try to open it. What happens to the desk after that? It's in evidence. It gets put in the closet. Because we can't have him climbing out. That's not serving my intent of depriving him of food, of depriving him of being able to go get his own water. I think it's very instructive when you're looking at the home dynamic, to not focus overly on the 30-second clips from the surveillance video or from the few videos that happen to be captured from the phone, but to look at the welfare check. When they go to that home that night, I mean, Officer Perez, he told you about how he thinks he could have done some things better. You want to talk about care, custody, control. When the officer asks, how'd you get those injuries? What happens? The defendant leans down in Benjamin's face and says, tell him, Benji, tell him what you did to yourself. About 20 minutes later, Brandon comes in the room. There's the police. Go back and watch it. He's like stunned. He's looking back and forth. What's going on, right? And then what does Brandon say? What are you looking at me for? Talk to the police officer. Who's in control of that house? Over the course of that video, the officers are there for just over an hour. Benjamin asks for animal crackers 4 times, and the defendant tells him no 4 times. He does eventually feed him at almost 9 at night. No one had asked him what Benji had eaten that day. Miranda says French toast, but that's after Brandon forgets that they had French toast. That's interesting. When you're looking at the ways in which Benjamin is able to articulate what's going on there in that house, they put him on the counter. He reaches behind him for baby food. He's distracted. The EMS has to tell him, stop, don't look at that. What are you doing? Every time they talk to him, even when they come and take him to the bathroom to show him his injuries in the mirror, who's sitting right there on the bed? Miranda. So to say that we got a complete picture is kind of the antithesis of this case. Nobody gets a complete picture until after the death has occurred. And that is directly related to the defendant's failure to get him medical treatment. I mean, when he is bringing Benjamin to the hospital because CPS told him you have to on the 21st, does he say, and by the way, we've been locking up all the food, locking him in his room at night. What do you think about that, Doc? Not in there. I mean, if you're providing proper medical treatment, wouldn't you tell the doctor the things that you're actually doing so that they can tell you, oh yeah, that makes sense, or oh no, maybe stop doing that. That doesn't happen. Also, what you won't find, because I expect the defense is going to go up here and say, oh, well, they're following the medical advice. I would say if you look at Defendant's Exhibit 34, which is it's the growth chart, but it's also the chart that says, okay, here's when Brandon took custody, like got sole custody of Benjamin, right? January 2019. You see how there's only 2 appearances to the doctor until that 2-year checkup, and then the next one is when CPS makes them go to the hospital. He doesn't see, in this entire period from January 2019, he doesn't see a single doctor more than twice. The pediatrician said, well, I would be concerned if I had seen the weight curve, the growth chart that showed all the plot points. Nobody had all the plot points. He wasn't going to his regular pediatric visits. There's an entire period here of almost 2 years where there's 1 visit.
15 minutes.
Thank you, Judge. And so the defense is going to get up here and they're going to say a lot of things about the weights and these alternative causes of death that conveniently are not previously present in the medical records, right? Like there's no heart arrhythmia condition, there's no seizure condition, there's no diabetes. No one even formed the opinion that he actually had those things. And isn't it convenient that those very same possibilities that the defense is trying to represent are the things that require the heart to be beating in order to confirm that that's happening, or that require that the brain chemistry be of a person that's living, right? especially when they are not bared out in the details. So I'm hoping that I've illustrated to you the defendant's specific intent to fail to provide these things. And
Objection, Your Honor, that's a misplacement of the burden of beyond reasonable doubt is on the state at all times.
Ladies and gentlemen, you will remember and follow the law as instructed to you for the charge of the court. What the attorneys say is not the law unless it is in harmony and in agreement with the charge of the court that I have read to you. Go ahead, sir, please.
in a little bit, Mr. Villarreal is going to get up here, and he's going to explain to you how the death is caused by starvation and how there was serious bodily injury caused by these omissions before the death, and that not only did he know that those conditions were occurring and could have caused serious bodily injury, but that that was his intent. And when you've heard all of that and considered all of the extensive evidence that you've been brought, we think you're going to find the only just verdict in this case, which is guilty. Judge, I'll reserve my time.